We got breaking news and a twofer, a Tuesday Two-Fer here on Legal AF Tuesday. We've got a Republican judge who just issued an order, Judge Royce Lamberth, against Kari Lake, major Donald Trump enabler and destroyer or attempted destroyer of Voice of America. In his new decision, he takes on the Trump administration, finding them almost in contempt. You'll know why in a minute. It didn't go all the way, but could. Going after Kari Lake and her dripping indifference that she exhibited during a sworn statement and a deposition. And then, for extra measure, goes after the United States Supreme Court and chastises his bosses at the Supreme Court because they keep making those darn emergency shadow docket rulings, which are not helpful to the lower courts, because how do you interpret the presidential value of half a paragraph? Welcome. I'm Michael Popok. You're on Legal AF on Tuesday. Let's get down to it. New order. Voice of America had always been a shining beacon for democracy around the world. That's how Congress saw it, in giving billions of dollars to it to publish newspapers, internet material, radio broadcast, and the equivalent on the internet. Think Radio Free Europe, Radio Free Asia, Radio Free China. Again, promoting American values. Donald Trump doesn't have any American values, wants to destroy that and take it away. It was always an arm of diplomacy and a way to create new Democrats and democracies around the world. Donald Trump couldn't wait to destroy that, so he issued an executive order, immediately fired 1,200 people, and tried to shrink it down to the smallest size possible while still meeting its statutory mandates of Congress. And that's the rub. That's the problem. They went too far. Right now, at the time of this hearing and the judge's order that was issued last night, Voice of America is broadcasting two 15-minute programs worldwide, one in one Arab dialect and one in another Arab dialect. That's the entirety of its radio broadcast on the internet or through shortwave radio. That's it. There's nothing in North Korea. There's nothing aimed at China. There's nothing aimed at Russia. There's nothing aimed at South America at all. No content at all. And this violates Judge Lamberth's injunction since April. So we've had all these filings where Lamberth has been very patient, but the patience has run out. In fact, he says at the final pages of his order, starting on page 18, about disrespect and effectively inviting the plaintiffs to bring a contempt motion to him, which he will conduct the proceedings around and likely sign it. Here's what he said. The court must offer an observation on the concerning disrespect the defendants have shown towards the court's orders since the entry of the preliminary injunction. That's back in April. It is the court's view that the defendant's disregard for its earlier orders to produce information would more than support a trial on civil contempt. However, I'm going to focus, he says, on the current proceedings. At a July 30 order granting the motion to show cause, ordered that the defendants produce all documents regarding their future efforts, their future decision to do another reduction in force, another firing of another 500 people. The defendants' response suggested that they were in discussions concerning a possible reduction in force, but that no course of action had been decided upon. Then, at an August 25th hearing, counsel for the Trump administration speculated out loud to the court that maybe eventually there'll be a RIF and that there was uncertainty as to how many employees would be subject to the RIF. Again, the defendants gave the impression that no reduction in force decision had been made. Yet, just hours after the hearing, the defendants initiated the reduction in force at issue in this case. Given the timing of those events, it strains credulity to think that the RIF was uncertain or a mere possibility, as defendants repeatedly suggested to this court. That said, the plaintiffs haven't asked for a motion or asked for contempt sanctions, and I'm not going to give it on my own. That said, the plaintiffs have not requested such proceedings, and the court declines to pursue contempt on its own. However, bring the motion. Now, here's what the court says about the United States Supreme Court. First, I want to play you a clip from Clarence Thomas, who's still out on his summer vacation. He doesn't start work again until Monday. So he decided to say, or 2 Mondays from now. So he started to say stupid things out loud. Like, I don't think that prior court rulings are precedent that I need to follow like the gospel. All right, so now you've got a United States Supreme Court justice who says that the entire framework, the entire foundation of the United States Supreme Court that I learned in law school and every constitutional scholar as well is that stare decisis, meaning that we make rulings based on prior precedent and guidance to the court. Yeah? As opposed to civil code, which is every judge sort of reads the code for themselves and figures out what it is. Here, you are supposed to apply prior case law, prior rulings. That is the stare decisis method of Supreme Court precedent being used as a foundation for future decisions. Royce Lamberth, in his opinion, says, I am not getting proper guidance from the United States Supreme Court. So how can I follow a 1-paragraph order that gives me no opinion, no logic, no analysis, no case law analysis, no factual analysis, and then you expect that to be precedent? I mean, the Supreme Court has gone out of its way, Justices Kavanaugh and Gorsuch, for instance, to go after certain judges and say to them, you're not following our precedent. And Lamberth saying, what is the precedent? It can't be the paragraph on an emergency docket, which is what the Trump administration is arguing. And even Clarence Thomas on the Supreme Court doesn't think precedent in a 50 or 100-page written opinion is worth the paper that it's written on. Let me show you Justice Thomas's position, and then we'll go back to Judge Lamberth here in this new order. Let's play Judge Thomas now.
You see originalism and stare decisis as in tension with each other, and what factors do you bring when you write an opinion that suggests maybe a line of cases should be revisited?
Well, if I find it doesn't make any sense, I think we should demand that no matter what the case is, that it has more than just a simple theoretical basis.
Right.
I don't think that I have the gospel, and I don't think that any of these cases that have been decided are the gospel. And I do give respect to precedent, but the precedent should be respectful of our legal tradition and our country and our laws, and be based on something.
So the Supreme Court isn't even respecting its own precedent. Why should lower courts? So here's what the Justice or Judge Lamberth says as he goes out of the way to go after the Supreme Court. Finally, the defendants on page 15, the defendants point to 2 stay posture cases in the Supreme Court that enjoined reductions in forces at the Department of Education and 6 other agencies. Okay, that means the Supreme Court on the emergency shadow docket, on short briefing, short record, no oral argument, issued 1 paragraph to allow the reduction in force or the firings at the Department of Education and at 6 other agencies. In doing so, the defendants invite the court to infer from those orders a blanket rule favoring reductions in force firings in this posture. The court, of course, accords the utmost respect to the Supreme Court's stay posture rulings. Yet, any appellate decision cannot provide precedential guidance without a statement of reasons from which the court can analogize to the present facts. And that is wholly missing here. Here's what the judge says on page 16. To follow the defendant's lead would in effect countenance letting the government fill in the blanks of the Supreme Court's emergency rulings, relinquishing the basic judicial task of deciding what the law is. And to infer an ironclad prohibition against preliminarily enjoining RIFs pending further litigation would disregard the essence of equitable relief. Equity is allergic to rigidity. So what's going to happen next with this? Well, for right now, 500 people are still employed, and the Trump administration is under yet another obligation by Judge Royce Lamberth to file with him exactly how they're going to restore programming to Europe, to Asia, South America, China, North Korea, and Russia. And he wants to know it soon. Now, they can try to take another appeal to the D.C. court of federal court for the D.C. Circuit, or they can try to take another emergency application to the United States Supreme Court. But Lamberth is right. The Supreme Court cannot expect lower courts to follow their lead when it's a paragraph, and when you have justices like Thomas who say they're not even following their own precedent. I'm going to continue to follow it all for you right here on Midas Touch and Legal AF. Take a minute, hit the free subscribe button for Legal AF on this YouTube channel. And I am going to post, as always, this memorandum opinion in Legal AF Substack for your review. Come on over there. Help us continue to grow that community. We do 2 live reports every day. We've got written articles that I think you're really going to find fascinating. You can't find anywhere else but Legal AF Substack. And consider becoming a paid member for about $7 a month. That's what helps keep the content on the air during these very trying times. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.